Interventions, Critical Thinking on Law from Birkbeck. A series of provocative engagements on cases, ideas and politics from the law school at Birkbeck University.
In this first of 4 recordings in the Interventions series, I want to talk about the case Lloyd and Google. We're going to focus on Lord Legate's speech in the Supreme Court. In my opinion, this is an important case, as it shows the failure of law to deal with corporate power. In this case, the claimant, Richard Lloyd, sued Google. Lloyd alleged that Google had breached its duties as a data controller under the Data Protection Act 1998, the DPA. Lloyd argued that Google had secretly tracked the internet activity of millions of Apple iPhone users. Google then used the data collected for commercial gain without the user's knowledge or consent. Now a key point. Lloyd put forward a legal argument that would, if successful, enable him to represent all those in England and Wales who owned an Apple iPhone and whose data had been used by Google. On the estimate given by the court, this amounted to around 4 million people. Damages would be approximately £3 billion. The case raises some important concerns about the regulation of powerful social media companies, human rights, and the viability of class actions. As we'll see, a class action, or in more technically correct language, a representative action, is an important way of proceeding against a company like Google. In the next recording, we'll look in a little more detail at Lloyd's argument. So, Lloyd is suing Google. In this recording, we will look in detail at Lloyd's argument. Lloyd was fighting a representative action against Google under the Civil Procedure Rules, CPR. The CPR rules specify that those in the legal action must have the same shared interest in the case. We can see that this relates to the way in which, on Lloyd's argument, the shared interest was the abuse of personal data. For our purposes, there's a second point, indeed a novel point under the DPA. The claimant was trying to break new legal ground by extending the principles in 2 previous cases, Vidal Hall and Gulati. Lloyd argued that if a data controller is in breach of the Act, then compensation can be awarded without proof of material damage or distress, provided that the breach itself is not minor. Moreover, the principle from the case Gulati could be extended still further. Damages could be awarded on the basis of the infringement of the right to privacy itself. Lloyd supported his position with the common source argument, the assertion that tort law and data protection law should be seen as identical regimes from the perspective of human rights law under both the Charter and the Convention. Lloyd supported his position with the common source argument, the assertion that tort law and data protection law should be seen as identical regimes from the perspective of human rights law under both the Charter and the Convention. Senior judges had made powerful statements in earlier cases that appeared to support Lloyd's position. These statements stressed the importance of the right to privacy, autonomy, and human dignity. Will Lloyd's argument win the day, or will the Supreme Court refuse his appeal and decide for Google? Find out in part 3. This is the 3rd recording on Lloyd and Google. So far, we've been thinking about how Richard Lloyd brought a representative action against Google for £3 billion in damages. Lloyd was arguing that Google, as a data controller, was in breach of its duties under the Data Protection Act 1998. Lloyd's argument was linked to a clever interpretation of the right to privacy that meant that he did not actually have to prove loss or damage to be successful in his case. Now we're going to find out why the Supreme Court did not agree with Lloyd's argument. In the Supreme Court, Lloyd Legate did not accept Lloyd's argument about the DPA 1998. Lord Legate's central point was that Parliament did not intend the DPA to give remedy for minor breaches of data protection law. Lord Legate also showed that UK and EU law were consistent. It's worth remembering that Lloyd was not arguing that domestic law should be disapplied. Rather, he was arguing that domestic law should be interpreted as compatible with EU law on the point that contravention did not require damages. But Lord Legate did not accept this argument either. He also rejected Lloyd's right to privacy argument, pointing out that tort law and data protection law were two different legal regimes. Both bodies of law were consistent with human rights, but did not have to have identical rules in relation to the recovery of damages. Finally, Lord Legate rejected Lloyd's argument that he did not have to show evidence of damage from the abuse of data. Rather, it would be necessary to show what actual damage had occurred from the misuse of the data. The contention that damages could be based on the hypothetical idea that Google should have paid each user a fee was rejected by the court. However, whilst Lord Legate dismissed Lloyd's case, perhaps he did hint that Parliament should amend the legislation. Given the limitations of group and representative actions, it's as if this case is urging the Parliament to act. In the next recording, we'll move towards some final conclusions. Hi, this is the fourth and final recording in our series on Lloyd and Google, and I'm here with Rosa to talk about the case.
As we know, Lord Legate has dismissed the case against Google, but can we read this case as hinting that reform might be necessary to prevent the abuse of corporate power?
I think you're right. I want to kind of go back to something Lloyd Legate says earlier in the case, where he says something along the lines of the mass production of goods and services, and he's also drawing attention to digital technologies, obviously, has made for the potential for mass harm, and that's what this case is about. And Lord Legate is stressing that legal redress must be sought for these matters.
That's a powerful statement.
I think you're right. I mean, I hear kind of distant echoes of Donoghue and Stevenson in this case.
Okay, but this is not about a rotting snail in a bottle of ginger beer, but it is about the way in which a company can abuse its power.
I know what you mean. I think what I meant was that Lloyd and Google suggests that the law needs to catch up with economic and social realities.
I see what you mean. Whilst the Supreme Court rejected Lloyd's human rights argument, might the right to privacy still indicate a way forward?
I think that's true. I mean, it's clearly problematic given the kind of the arguments that we find in the case. But one of the things that is brought together in the arguments in the Supreme Court is the link between the abuse of privacy by newspapers and the abuse of personal data. And I'm wondering if that is the kind of context that privacy arguments have to address.
So could privacy arguments be used to prevent the exploitation of personal data?
I mean, I would hope so. I'm hoping that there's a way forward with that kind of argument, despite the Supreme Court's ruling in this case. But I think I want to make a more general point. I want to draw from the philosopher Hannah Arendt, who says that the law must grant all people status and dignity. Now, clearly, Hannah Arendt's not talking about digital technologies, but I think that general point is a useful way of interpreting the case. I mean, would you agree?
That's interesting, but I think the idea resonates more with the ruling of the Court of Appeal rather than the Supreme Court.
I think that's true. It certainly is as a legal argument. Yeah, I think what Arendt is saying does seem closer to what the Court of Appeal rather than the Supreme Court say. But it's a way of framing the case, I think. I mean, what though? Because obviously Lord Legate makes that point about the distinction between various legal regimes. I mean, do you have a take on that? Do you think it might have something to do with one of the problems that this case reveals?
Okay, from this perspective, Lord Legate's distinction between various legal regimes is significant. It shows how the general protection that the law can offer is not sufficient.
Yeah, I think I agree with you. And what the case points at is that there needs to be legislation. Parliament needs to legislate. For me, that's a clear message that comes out of this case. I mean, would you agree with that?
I think so. Without reform, corporations that exploit their power will continue to get away with it.